Ladies and gentlemen, boys and girls, and co-parents of all ages, this podcast is for you. Introducing and the centering the Amicable divorce expert, Judith Weigel.
Joining me in centering today is one of my absolute favorite attorneys of all time, Matthew Smurda. And Matthew is here to talk about our our current celebrity divorce series, and that's about Charlie Sheen, Denise Richards, and something that grabbed my eye in the press. But Matthew, first of all, thank you for being here.
My pleasure. Thanks for having me again, Judy.
Okay, this is going to be great. Great only because in these celebrity divorce series, we learn an awful lot through the eyes of the celebrities and all the media that they get, but they're aspects of everybody's divorce, but they're such good yardsticks for us to look at in terms of measuring our own divorce. So here's what caught my eye about a week or so ago. The headline, Denise Richards blindsided, in quotes, by Charlie Sheen child support ruling. Okay. The word blindsided caught my eye because here's why, and I'm going to ask you to speak to this in a second. I'm breaking this article up into bite-sized pieces. 2.5 Men star Charlie Sheen will no longer have to pay his actress ex-wife, Denise Richards, any child support. The actor's request to stop paying his ex-wife child support for their two daughters, Sammy, who's now 17, ready to graduate from high school soon, and Lola, 16, has reportedly been granted. Richards, on the other hand, did not file any documents challenging the ruling. Well, the ruling only happened 1 or 2 weeks ago. Do we expect anybody to file of this level? Would we expect anybody to file within a week or two after a ruling, Matthew?
Well, I would expect at that level of money and that level of prior litigation, I would have expected documents to be filed well in advance of a ruling. That's particularly unusual that a ruling would be made without her having an opportunity to oppose whatever request he was asking for, because the way it normally goes is whoever's asking for a change, the party seeking modification, would file documents. They're called an RFO, request for order. Right? And that even applies in this instance where they had settled their case in the past and they're modifying the judgment, called a post-judgment RFO. So whoever wants the modification, in this case, Charlie, would have filed paperwork, and that would have generated a hearing date. And that would have been true whether they're going through the public court or whether they're using a private judge. Either way, documents have to be filed. And those generally have to be filed at least 16 court days before the hearing, which is basically about a month, a calendar month. So normally you would get the documents and you'd have almost a month to tell your side of the story if you're Denise in an opposition or responsive declaration to the RFO. So, and actually, really, for the purposes of calculating child support, a response is almost necessary because what also goes with the response is also an updated disclosure of someone's financials. We call it an income and expense declaration. And it's essentially this court form that's really like a personal profit and loss statement that says, here's everything I'm earning, here's what I'm spending, and a couple of other pieces of information as well. This is what I'm doing for work, this is my situation, these are my extenuating circumstances, but a standardized document so that if and when this does reach a judge, the judge has, column A, here's Charlie's financials, column B, here are Denise's financials, and then those are analyzed, generally speaking, in this computer program called Disomaster, which has the formula that we use to calculate child support in California. So again, going back to the original question, this doesn't happen by surprise, generally speaking. Usually, there is notice. You have due process rights to notice and an opportunity to be heard. So something certainly is fishy here. What I suspect may have happened is, and I don't know this with certainty, but what I suspect may have happened is whoever was her last lawyer probably got out of the case after the last litigation was resolved. And what happened was there was probably what's called a notice of withdrawal filed by the lawyer, which doesn't mean anything bad happened. It doesn't mean anything. It just means my work is done here, so now I'm off the case and I can come back at any point. But that was probably done, and perhaps the address that was left on that was an old address. And so maybe something may have happened and paperwork was sent to a wrong address. That's certainly possible. But at that level of litigation, one would expect, number one, there'd be notice to her just as a courtesy of some sort. Or two, a really cautious attorney would have had her personally served with paperwork. So whatever the case may be, the judge apparently felt comfortable enough to proceed based upon whatever notice was given to her. I'm sure the judge asked and asked, why is Miss Richards not here? Have you heard from Miss Richards? I'm sure there was some inquiry. Hopefully there was. But presumably that was to the satisfaction of the judge, who felt comfortable enough to, reduce child support to a zero, basically.
So here are the missing blanks here. I'll fill in the blanks.
Okay.
I'm reading from an account, of course. Denise wasn't at court because she's working out of state, which Charlie was well aware of. Charlie initially filed for this modification 2 years ago. I mean, supposedly I'm reading this, but you
Sure.
said a couple things that were interesting to me that I hadn't thought about as I was, dissecting this case. So
Sure.
supposedly Charlie filed 2 years ago because his income apparently has changed. He's not on 2.5 Men anymore. He's not on any TV series, nor have I seen a film come out in the last few years. Now, they were only married for 4 years, from 2002 to 2006. The kids were really little when they got divorced, but they've been co-parenting since that time, and now the kids are ready to graduate from high school in a year or two.
Right.
But supposedly, here's what it says. Charlie kept pushing the court date. Denise was never served with this latest court date. But see, I said the same thing you did. Well, wait a minute. There's a proof of service that has to be filed whenever she's updated on the change of date. You have to be updated on the change of date so you can participate. So there may be an exception to that. Go ahead.
And we don't know with certainty, but a lot of times what happens is when lawyers are involved at the end of a hearing, and let's say a judge continues the case or sets a new date. I had this happen earlier today on another case. The judge will ask, is notice waived? And what that means is, because there's 2 lawyers there, or maybe even if there's just one lawyer there and someone representing himself, the judge is asking, do you waive the right to have paperwork issued notifying you of the new day? So if someone is there, they assume, for example, if 2 lawyers are there, the lawyers are going to put down the day and inform their client of the same, so they can waive notice. I presume it's possible that her lawyer was present at the last hearing before the new date was set and they waived notice. And that may be how she didn't know.
Maybe, because then my other question was, and we know, the pandemic has kind of underscored this and put it on steroids, but even before the pandemic, if you can't make it to a court date, then you call in. You either get accepted the court call, you apply for a court call, or it's kind of changed a little bit since the pandemic, but you arrange for the phone number and the time to call in so you can participate, or you can do a Zoom link, right?
Correct. You have for general family law cases, and especially one where child support is being modified, you have the ability to just go on the website. It's called LA Court Connect, and it's even free right now. It used to charge per appearance, but now it's free. You just fill out the website form. You can appear by telephone, by video. It's whatever's convenient for you, and you can do that for pretty much everything.
So I guess she really didn't know. And there are times when people don't really know that there's a hearing.
Sure.
Depending on how you get somebody served, what if you don't go through a legitimate process server? What if you go through a friend who may falsify the proof of service document?
Right. Right. And if that happens, then what you have to do is you just have to come in after the fact within a reasonable time once you become aware of whatever it was that happened, make the judge aware of the circumstances and either see if you can get that relief set aside or modified or changed, or at least, somehow be able to tell your side of the story. I mean, I had a case recently where somebody claimed they mailed something to me. I never got it. They never emailed me, never called me, never told me about it. And the court ruled on it. And I have to do that very thing. So,
Okay.
You just go back in and you just explain, I never got a copy. I never got notice,
Okay, so that's really good for people listening to know that if this ever happens to you, somehow there's a court date and you honestly weren't aware of it and you really would have gone and participated, that there's a recourse.
Absolutely. Well, I wouldn't say necessarily a recourse, but there's an option. You can go and explain your side of the story to the judge. And I'll say most judges, especially during the pandemic, have been receptive to the fact that things do get lost in the mail. People make mistakes. Things happen. And so because of that, they're usually willing to do it the right way, because everybody prefers. That's the odd thing about this case, the Richard Sheen case, is, most people prefer to do things the right way on the record, both sides participating, because that's the safer move whenever you're doing anything, even just from a judge's perspective. That almost ensures, doesn't ensure, but it improves the safety of the judge's ruling, so to speak, if it were ever to be appealed and they were to be evaluated by the Court of Appeals. So it's good practice to allow both sides to participate.
Okay, so Denise may be able to have a further discussion with the court. Now, this opens up a few more issues, and especially with people who travel and go out of town a lot. And yes, actresses, actors go out of town a lot if they're on location shoots. So going back originally when they got divorced in 2006, they had two small girls. And Charlie was well known in the newspapers for having a somewhat erratic behavior. I don't know whether Denise got sole custody at that point. I think it was modified to joint custody. But let's address the issue of if custody starts out in one category, sole custody, can it be modified to joint custody later on?
Yes, the answer is yes. Custody always remains modifiable until the children reach the age of majority, which in California, that's reaching the age of 18. Once they reach the age of 18, the court doesn't have any more power over their day-to-day lives because now they've become legally adults, right? But until then, it's modifiable at any time. The question is just what has to be shown in order to obtain a modification. And so there's kind of two different types of modification. There's one before the divorce or the parentage proceedings are final, and there's one after they've been finalized, but changes need to be made, a post-judgment modification. In the former, before the case is finalized, all you have to do is just come in and show whatever change you want is in the best interests of the child, for whatever reason. Somebody got a new job, somebody moved to a new place, somebody's in a new school district, whatever it might be. Best interest of the child. If it's post-judgment, though, there's a case called Montenegro that basically says before you do that best interest of the child analysis, the person who wants the change has to make a threshold showing of what's called a material change in circumstances. So not just that something has changed or is different, that it's material, it's important, it's significant. And again, that could be anything. It could be someone has to move, somebody had a DUI, somebody has, whatever.
Substance abuse has been cleared up.
Exactly. But it's always modifiable, no matter what. You can't stop a modification.
Okay, excellent. So at some point along the way, things calmed down for Charlie and Denise because, now I would know this, Matthew, you wouldn't, but on the Beverly Hills Housewives, which I watch because I have cats, not kids, you have children and a wife, therefore you have other things going on at night. But this was an excellent window opening on a couple things going on with Charlie Sheen and Denise Richards' divorce. And it sounded like 2 or 3 years ago, in the reunion show that they had a wonderful co-parenting relationship. To the extent that I assumed it was joint custody, what Denise had said was, Charlie is invited to every single event for the children in my home. He's always welcome. I want the kids to respect their father. I never want them to believe what they're reading in the press as the end all be all. So I'm thinking, this is great. This woman is a saint. I love her. And she even described a Thanksgiving dinner where Charlie did not show up at the beginning of the meal. There's a knock on the door. There he is. And she said, hey, come on in. We're having dinner. My parents are here. Come on in. You're welcome. And he said, well, I have somebody with me. She looks outside and she assumes it's a prostitute sitting in the car. And she said, it's Thanksgiving. Everybody has to eat. Okay, this woman got double saint
it's very, very
points
nice
from me. I thought this was really, really good.
Very nice.
This is all fine and wonderful. So in a modification of custody, and assuming you're comfortable with the children going to the other person's house, does it matter if one person has sole custody as long as they're opening up the visitation schedule to the other parent?
Well, I think it certainly matters. And I think your question is, does it matter from the court's perspective or does it matter from the parent's perspective? I think that's a big difference. Judges generally would look fondly upon that. That's the kind of thing they would encourage, that kind of co-parenting and cooperation. Because if the parties are agreeing and everyone agrees this is safe and it's good for the kids, then there's no reason for a judge to interfere. Judges in theory are only supposed to interfere and do so when it's necessary, essentially to protect the children and make sure that they're safe and their best interests are being upheld. So I think a judge would find it relevant, though, to the extent that a party comes in maybe and they have a disagreement down the line about what custody orders should be. And, in this case, Charlie comes in and says, hey, I'd like more custodial time. Maybe he asks for some kind of holiday or visitation schedule. And the fact that he was welcome in the home on Thanksgiving certainly is relevant and can be considered by a judge. I don't know how much, probative value it would have, excuse me, to the extent that, if he's asking for unsupervised custodial time, eating dinner at Thanksgiving with all the family there, that's not unsupervised time. So,
True.
You could feel a lot more comfortable if, there was some behavior concern or whatever it is, that everyone else is there to make sure the kids are safe. So I don't know how far it goes, but it's certainly relevant. Sure.
Well, you brought up another point, Matthew, and that is about supervised versus unsupervised time. And I downloaded a lot of articles because I wanted to do as much research as I could to fill in the blanks that I didn't know about. I think there was a point, I think I read an article that said there had to be supervised time with Charlie because there was a period of drugs and alcohol and he had to go to rehab. And then I think he cleaned up his act. And I think it's well known in the news, anger management issues came up every now and then, especially with Chuck Lorre and some of the TV shows that Charlie was on and then was no longer on. They took him off of 2.5 Men. But I think that was in the past, and supervised visitation is no longer necessary. I just think he's changed enough from reading these other accounts. But let's go to child support and everything that's involved with child support. First of all, what does child support cover and what doesn't it cover?
Sure. So child support is supposed to cover the basic necessities of a child. So the most obvious would be, food, shelter, clothing, basic living expenses, things like that. It should cover other things too, though. It should cover their entertainment while they're with either parent. It should cover pretty much everything encompassed in living expenses. There are some exclusions to that. For example, if there are medical care costs that are not covered by insurance, normally those would go outside of child support. The court would expect the parties to either split those or have some kind of proportional responsibility for them. The health insurance premiums are something. Health insurance premiums normally would be paid by one party if they have access to it through employment, or if they have the ability to get it at a lower cost, or perhaps the parties should both be responsible for it, but the court wants to make sure that that's paid for. So that falls outside the scope of it. And then there can be other things too, such as private school tuition, if the parties agree to send the children to private school. Sometimes extracurricular activities, if there's disagreement between the parents as to who should be, whether the kids should be participating in the extracurriculars, things like that fall outside the scope of child support. But in theory, it's supposed to cover everything. And then you get into an interesting discussion, which I'm sure we'll talk about in a second, where when you have very high earning people like Charlie Sheen was when he was the highest paid TV star, in the country, how do you deal with child support in that spectrum?
So let's segue into that. I believe I read $55,000 a month in child support, which
That's
is
possible. Yes.
It's possible because of what he was earning, at least on 2.5 Men. And then there's all those wonderful films that he did that we don't know what those contracts are like and what kind of residuals or intellectual property fees, royalties, whatever he gets.
Right.
But in the world of modifiability, things can change. And they did change with Charlie Sheen. He went from being the highest paid actor on television, and there's no disparaging comments about him not being there now, because he's still a wonderful actor. It doesn't matter whether he has a TV show or not. But when that changes, then you have to file for a modification of child support, right?
You would. Otherwise, the support's going to remain in effect. So if you have a change in your circumstances, and this applies to anybody, if you lose a job, you have some extraordinary expenses come in, your business suffers, whatever it might be, the burden is on you to file for modification with the court. And it's usually important you do it sooner rather than later, because if you were to file something today, as we sit here, it's the end of October right now. If you were to file something today, in my other cases, I'm having hearings set anywhere from December through February for things that are filed today. So you're looking at a 2 to 5 month delay. And that's important for child support, because if you don't get to court for 2 to 5 months, in theory, you have to continue paying that child support order as it is, because that's a court order, okay? But if you have a financial hardship and you can convince a judge of that at the hearing, the judge has the ability to go back retroactively and modify the support as of when you filed. So if you were to do it today and you get into court in February, the court can go all the way back to November 1st, the next first day of the month. And, if you were paying and you were able to do that, great, you're going to get a credit. But if your circumstances were so dire that you couldn't afford to pay, you just couldn't do it, at least the court understands and has the ability to go back and modify that so you don't owe an arrearage. So that's why it's important to file. And it sounds like Charlie did that 2 years ago.
Well, truer words were never spoken, Matthew. It's like you read these articles on your own, because another sentence in the article is, Charlie Sheen has allegedly not been paying Richards any child support for at least 4 years.
Mm.
So it's been more than 4 years since Charlie was not on 2.5 Men. It's been quite a while. In fact, 2.5 Men is not being produced anymore, just reruns. So apparently, if what I'm reading is true, that the judge said Charlie does not have to pay a dime. I'm going to bring in the visitation schedule in a minute on this. If Charlie doesn't have to pay a dime, it kind of sounds like the judge went back retroactively and wiped away the 4 years that Charlie wasn't paying. If in fact, in year 5, 6, 7, something like that, he was still at $55,000 a month, and not on 3.5 Men or making films anymore.
Sure.
So
Yeah.
it kind of sounds like he was sticking to the old number while he wasn't really earning that level of money anymore.
It's possible, and if he did overpay, he would get a credit back, and you'd have to figure out how to do that. But if he wasn't paying, as is being alleged, then he's just not going to owe a massive arrearage, for child support.
Yeah, it kind of sounds like it evened out. All right, now, so child support is based on what both spouses make and some other things like who's filing head of household, how much co-parenting time each parent has, and those are the basics, right? Those are the basics. What each parent makes, who's filing head of household, and what is the co-parenting time.
Correct.
Those are the big chunks. Okay, so let's logic this out a second. Apparently, Lola and Sammy had their primary residence listed as Denise Richards' house. And they had visitation time with Charlie. It sounded like it was fairly open as they got older when they wanted to see their dad, which sounds great. And then the reason, a reason, you know what? Now I actually can't figure this out. Okay, so here's the other piece of it. Here's the other piece of it. Maybe you can make sense of this. So part of this story is Sammy, the older daughter, last year decided that the Denise Richard household, and she remarried, by the way, a couple of years ago, 2-3 years ago. She remarried a man named Aaron. And he moved into Denise's house.
He's the Reiki guy, right? He does Reiki.
He's the Reiki guy.
Yeah, I've seen that.
That's right.
Yeah.
That's how they met. She went to his health spa, and he does all these advanced treatments, and they fell in love. The rest is history. And they got married, by the way, on the Beverly Hills Housewives.
Ah, very nice.
They walked down the aisle to a heavy metal song, which I loved more than anything. I couldn't believe it. They did exactly what was representative of them. And how cool is that? And the girls were in the ceremony. Charlie was invited. I don't think he showed up, but he was invited. Okay, so when Denise is out of town shooting, which she does go in and out of town, both girls would stay with Charlie. And then when Denise is back in town, they stay with her and then see Charlie whenever they want. So Sammy, the older, contends that she cannot live at Denise's house anymore. It's just too hard. The rules are too restrictive, and calls it a hell house. It was on TikTok. Okay. It's now gone private. So Sammy is living full-time with Charlie. Lola's only staying with Charlie when Denise is out of town, and then goes back to Denise's house when she's in town.
Okay.
So why would child support be wiped away for both of them? Could it be just the overpayment possibility?
That's certainly possible. I mean, we have to kind of isolate each effect or factor. So first, the timeshare issue. If anyone has a 0% timeshare of a child, they're not entitled to child support, generally speaking, under the formula. So with respect to that child, that makes sense. And if, one fight probably was historically, Charlie could prove that was the case going back a number of years. So historically, the timeshare was 0%, right? So that's the one issue. And then I guess you could look at what the actual status quo is for the other child, how often she is in fact staying at his house versus her house. And if that amounts to a 0%, the same rationale will apply. So if it's 0%, it's 0%, it's $0. That's the way you look at it. Now, there's another thing too. There are, and again, I may be butchering the name here. There's these things called Jackson credits, and I believe Tremonti credits. That can happen where a court order says one thing as far as custody goes, but the parties end up deviating from it. And the children stay with the non-custodial parent, and maybe the non-custodial parent pays for the child or the children's living expenses or whatever it might be during the period of time where they're supposed to be paying child support, which is what's supposed to be paying for those things. So if you can prove that you've done that as the non-custodial parent, then you're entitled to a credit that can then offset whatever child support might be owed. So that could also be a big piece of it, which, folks at that level of lifestyle, you're probably talking a lot of money that's being paid. I mean, $55,000 a month, presumably that is a number that it could be one of two things. It could be the result of the formula, the child support formula. It also could be a reflection of what the reasonable needs are for these children based upon their lifestyle. So we don't really know, but if Charlie was paying $55,000 a month in expenses, he shouldn't also have to pay $55,000 a month of child support.
There's a third option, and the third option is Sammy the older lives with Charlie exclusively, and Lola the younger only stays with him when Denise is out of town. But here's the other twist. Charlie may not be making any money at all right now. I don't see any films or TV projects or anything. Meanwhile, Denise keeps working. So Denise never made as much as Charlie because that was pretty extraordinary money. But she at least made livable money. I mean, she was on, The Young and the Restless, one of the soap operas. They pay very good money. Oh, The Bold and the Beautiful, sorry. I don't watch the soap operas. I actually work all day. But from the Beverly Hills Housewives, I believe I got that it was The Bold and the Beautiful Denise was on. And then she does her fair share of films. Maybe not as a lead actress, but you still get paid. And then she's no longer on the Beverly Hills Housewives, but she was on for, 2 or 3 years. So with that in mind, if Sammy is exclusively now with Charlie and Lola's with Denise as at least primary custodial parent and whenever she wants with Charlie, does this kind of even itself out with Denise making some money, Charlie not making what he used to, maybe living off of investments and savings? Would that kind of could it cancel out any payment between them in terms of monthly support?
It's certainly possible. Yeah. I mean, it's certainly possible that kind of change in income as well as the timeshare change would have a negating effect that offsets the two, support for child one, support for child two, that just kind of nets out to basically a zero. So that's certainly possible, yeah.
Okay.
Certainly.
But then they still have to share the other expenses, I expect, that beyond food, shelter, and clothing. The girls are in private school. They're not in public school. So they're in private school, and we know that that's anywhere from $2,000 to $4,000 a month per child in LA.
Right.
So they would still have to share that, I guess. And then any other extraordinary expenses.
Any sort of unreimbursed medical.
Right.
If the children have like tutoring, ongoing tutoring, therapy, things like that, all those things, there'd be some sort of cost allocation expected for those things.
So, Matthew, in real life, when we're dealing with non-celebrities, whether they have money or not, it doesn't matter.
Of course.
Do you find that there's a huge fear among men that they will lose custody rights?
Yeah, of course. Yeah, I mean, I would say it's a fear among everybody, to be honest with you. But sure, I mean, men come into it thinking that the deck is stacked against them. And I think somebody did a study, I think statistically it is, if you look at the aggregate of all, divorce or parentage cases, it is stacked against men. However, that, I try and calm them down because at least in California, depending on the child's age, the public policy is to get as close to a 50% timeshare as possible, taking into account the child's age and then any other factors. And judges are trained by developmental psychologists and other experts as to what kind of standard, quote unquote, custodial arrangements you can have for children. So, the law is on men's side and women's side for 50-50. And, what does 50-50 or approximately 50-50 mean? I mean, you have to come up with a schedule that works for the child. And you have to look at all the factors. What's the distance between the two homes? Where do they go to school? What's their schedule like? And taking all those into account, it may not be feasible to do that. But the goal is to give approximately equal time to both parents to ensure regular and frequent contact by the children to both parents, as long as it's safe and appropriate to do so. So I try and calm men into understanding that. But of course, I'm sure they've all heard horror stories, and, horror stories exist where people do things like get bogus restraining orders and make these false claims in custody that lead to very minimal custodial timeshares, which are unfortunate.
Well, how is the deck stacked against men even now? What does that look like?
Well, I think it depends on, again, the circumstances. It's hard to give a global answer to that. But, let's say, for example, you had a situation where the father works more hours than the mother, or the mother stays at home. Right there, you kind of have the deck stacked against you in the sense that the father presumably doesn't have the equal ability to the mother to have a true, equal, identical timeshare that she does, just by virtue of his work schedule. And the mother has the ability to be there. So all of a sudden, right there, somebody who works a 9 to 5, or, let's say they work a night shift. I have a case right now where the parent claims that he works from 2 p.m. till 3 a.m., 5 days a week. He can't have joint physical custody. He'd never be able to see the child, So in that sense, that's a common thing. But again, that's not to say that, women can't have the same work schedule too. I mean, we all know women work equally as hard, if not harder, than men do, depending on their job, profession, things like that. So they're faced with that same issue as well, oftentimes. Another thing would be, if the man had any kind of history of substance abuse, alcohol abuse, it's all too easy for someone to assume that, if an allegation is made and somebody had a DUI or some kind of crime or something in the past, or they went to a rehab facility, that it's just presumed that they're an alcoholic. So what they have to do, and this happens unfortunately a lot in domestic violence litigation, is, the man is almost deemed guilty until proven innocent with a substance abuse problem. And so what I do in a lot of my cases is, if I have a client who claims he's sober, he doesn't use alcohol, we use a program called SoberLink. And we use that and we test voluntarily just to prove that my client doesn't have a drinking problem. So when we step in to the courtroom to have our litigation on this restraining order, we had 200 plus clean tests from SoberLink taken at all hours of the day. It's impossible to have that if somebody has a true drinking problem. So, things like that are just examples of the deck being stacked.
I want to clarify the difference between custody, what it means, and the co-parenting schedule, what it means. This is how I explain it. Tell me how you would address this. When I work with people, I say custody is a category of decision making. If you have sole custody, one parent makes the decision on where the children live, what their education is, religious upbringing, all of that. If you have joint custody, both parents have to be involved. Is that how you describe it, or do you describe it in another way?
Well, I do. And what I do is I say there's two areas of custody. There's legal custody and there's physical custody. The legal custody is exactly what you just said. It refers to decision-making authority. Decision-making on all issues pertaining to the child's education, health, welfare, religious participation, things like that. And you're exactly correct. You can have sole legal custody where one parent's the decision maker, or you can have joint legal custody where both parents have equal decision-making authority. And if they can't reach an agreement, then they have to go to court to get the court to resolve it. So I explain it that way. And then physical custody is just that. It's just timeshare. It's what's the schedule, what's the day-to-day or the week-to-week schedule look like.
So when I see minute orders coming out of the court and people come to me for mediation or for whatever, I see the two-word phrase, or 3 words, primary physical custody. But there's no law, is there, that literally uses that concept of primary physical custody?
No.
Why does the court still use it?
Well, you're exactly right. It's maddening because there is no definition of that in the family code. I'm not aware of any case law that defines it, but you'll find it in minute orders. You'll even find it on some court forms. These boxes you can check, these agreements that you write in and things, it's there. So again, it's not a legal term, but it's something to be aware of. Primary is just what it sounds like. It's just the parent that has the majority or the primary amount of time with the children. So if you're looking at the hypothetical we talked about earlier, if you have a working father who works, 40, 50 hours a week, presumably the mother in that circumstance is going to be the primary custodial parent just by virtue of father's work schedule.
How does that affect decision making? So another fear with men that I see is I have to have joint physical custody. How will I then be assured that she or the other spouse will not take the children and move out of state and then I can't see them?
Right. So a lot of concerns there. That's one of them. Fear that the other parent will move away. Fear that it'll affect decision making. But you have to separate all of these different things. In that example, I think the fear about move away is that there's a different standard that would be used if a parent had sole physical custody versus joint physical custody when it comes to analyzing a move away. But as far as I know, there's no, having quote unquote primary wouldn't cause that different legal standard. However, as a practical matter, the court is going to look at the status quo, and I think the point would be well taken, and I would argue this if I represent the mother, that if the children are used to being with mother 5 out of 7 days a week, or 24, 25 out of 30 days in a calendar month, why would we all of a sudden strip them of that and give the father, the same, if not more, if the mother has to move away? It's inconsistent with the status quo. So it's more of a practical concern. It's a valid one, but it's not a terminating sanction or a death sentence to not have an equal 50% timeshare for purposes of a move away. There's a lot more factors the court's supposed to look at.
What if you represented the father who worked a long day, earned a great living, ready to pony up and pay child support, but could not pick the kids up from school 2 to 3 days a week, couldn't do that with his job? What should be checked for custody? Sole, joint, right. How would that work? And then what's the co-parenting schedule like?
Well, as far as the argument goes, you would have to, if you're talking about a move away, you would have to come up with a very good plan, the best plan you could under the circumstances, assuming mother is gone. And so if that means father cutting back his work schedule and utilizing, some sort of childcare, whether it's a babysitter, after school program, Boys and Girls Club, whatever it ends up being, you'd have to come up with a pretty good plan to figure out how these kids are going to be taken care of. But you would have to make this is more about mom versus dad. This is about California versus, Texas or New York or wherever mom's moving. And, these children's contacts are here in California. They have their medical records here. Their pediatricians here. Their pediatric dentist is here. They've only gone to school in whatever, LA Unified School District or whatever it is. All their friends are here. They've been playing soccer here. You would have to tie all of those things that are here, all of which are going to be disrupted by this move. So you would have to solidify their contacts with the community. But, if you're looking at the initial stages where you're trying to figure out, okay, well, how do we come up with some sort of interim or initial custodial schedule that doesn't become a death trap for a move away? Things you could do to equalize would be, how much vacation time does father get? Does dad have 3 or 4 weeks paid vacation? Does he have any holiday breaks? If so, then maybe dad gets all or most of those breaks to equalize the timeshare out a little bit. So while in a regular work week, he might only be able to do like a midweek dinner and do the weekend, you can equalize that out during the break time. That's really the best you can do as far as the schedule goes, unless and until dad's willing to move his schedule around. And, maybe he is. Maybe he can take Fridays off. Maybe he can leave early on Mondays and come in late on Tuesdays, and that can capacitate an overnight. You really have to kind of get fact specific.
So it behooves men, what I'm listening to you say then, it behooves men to look at how they can adjust their work schedule if they really want joint legal and physical custody and participate in the upbringing of their children on a daily basis, midweek and weekends.
Well, there's one thing I want to correct you on there. the legal custody should not be contingent upon the physical custody. What I mean by that is that father still has the ability to make decisions on medical care, education. Just because he's at work doesn't mean mom can't pick up the phone or the doctor can't pick up the phone.
Yeah, work schedule has nothing to do with that. I guess let's focus on the physical custody.
So the legal custody really should be joint legal under that. I mean, when the circumstances where you wouldn't have true joint legal custody, joint decision making, you'd look at things like, is there real difficulty of these folks being able to communicate and co-parent? Is one unreasonably difficult? Is one not conveying information, not having a free flow of information? Is there domestic violence involved? Is there a huge geographic distance? If let's say father lives in Georgia, mom lives in Los Angeles, that would be a pretty good case where if the children are in Los Angeles, mom should have sole or some kind of final decision-making authority because dad's just not there regularly. But other than that, joint legal custody really is kind of the way to go. And if there's a major dispute, in theory, the parties can take it to court and figure it out if they reach an impasse. But
the real issue comes with physical custody.
It does. The real issue comes with physical custody. That's where both parents' abilities to be involved, their schedule, all of that really comes into play. You have to look at all that, the day-to-day life.
It's interesting with people in the film and television business, especially people in the film business, that they do travel a lot. And things do have to be adjusted. And, you're riding high one day and all of that changes in your career in a few years. But it's not dramatically different from other people. And I think the pandemic showed us this, that jobs changed. The way we work changes. And so did you find in the clients that you've been seeing, new clients and old clients during the pandemic, which was last year and this year, how much has that affected custody and child support in the way we've just discussed it?
It's had a significant impact because for many people, they become more available to be there for their children because now they don't have to go to downtown LA or Century City or Santa Monica or Playa Vista or wherever it was. Now they're only going there maybe one day a week. And the rest of the things they're doing on Zoom, or over the phone. Travel schedules have reduced for many, many professionals. People, who used to travel to New York every other week or to Chicago every other week, Florida, whatever it is. They're doing it maybe once every other month now. So I've seen the burden getting lightened on working parents in that respect, which has given them a better chance to exercise more time. And correspondingly, if they're getting more time, if they were paying child support based on a higher timeshare, they could be entitled to a reduction. The obvious, the pandemic decimated many, many industries, and people wanted to modify their child support downward. If you're a musician and you make your money from touring income, you didn't really have any touring income pretty much probably for most of 2020. You might now that things are opening up and people are vaccinated and all that, but for 2020, there were no concerts, maybe other than those, Zoom ones or digital ones or whatever it was, right? If you are pick your industry, right? If you are a restaurant, you probably took a pretty big hit there, right? If you own a restaurant. If you are a transportation business, nobody was going anywhere. Pick whatever you want, whatever business you're in, it probably took a hit. And there are other businesses, there's actually a converse of this. There's other industries that surged. I had a case where I represented the ex-wife of a guy who is an executive at a video game company. He had his best year in 2020 because everybody's staying home playing video games. Their sales went through the roof, So it just depends on what end of the spectrum you're on.
And so you did a lot of modifications, either up or down, did you not?
Upward modification, that's right.
So I was so proud of the legal community in Los Angeles last year when everybody was scrambling and trying to figure out how to service their clients. The courts were closed for a little while so they could reorganize. And people's work schedules were disrupted. Sometimes their money was disrupted. And I remember being on the listserv of Los Angeles County Bar Association watching attorneys talk to each other and just saying, we're just talking our clients down off the roof. Everybody has to compromise. Everybody has to do the best they can. You can't force somebody to pay if they're not making the same income.
Right.
And did you have a lot of those discussions?
You know, I did. And it wasn't just about child support. It was about a lot of different things. It was about all financial issues, really. Yeah, it involved child support, spousal support. We have, in some cases, these ongoing spousal buyout payments where there was, an equalization payment for one person getting more assets. They had to pay over time the other spouse, and they weren't able to do it. It was financed in monthly installments. There were attorney's fees ordered where they were ordered to pay the other side's attorney's fees or my attorney's fees.
Well, I didn't think about that, Matthew. That is very important.
All of it.
Yes, because you have a family to feed too.
That's right. But, I think just, like everybody, we all just kind of did the best we could and just tried to figure it out, make it work, come up with a new way of doing things. I think we've done that. And, I'm busier now than I've been ever in my career. My colleagues all feel the same. We're feeling there was a surge of new cases when things started, opening back up a little bit, and now those are making their way to litigation. So we're all just doing the best we can.
And so to end this, since this is a podcast about how to have amicable divorces, do you try to get your cases settled out of court as much as possible?
I do. I really do. If a case can be settled, I'm happy to settle it, and I certainly encourage everybody in every case to give a good faith, meaningful effort towards settlement so that if you can't settle and you end up going to trial, you don't have any regrets. You didn't miss out on the opportunity to resolve it, and you gave it a good faith effort. So I really do. And, look, most of my cases do settle. Over 90% of them settle. It's a question of when. Some settle quickly. Others, it takes some time. It takes what I call the bad taste of litigation. It takes people working their way through the process, being heard, having their side of the story told, all of that. But most of my cases do settle, and I'm always happy to settle them because the thing about settlement is it gives you control, and it gives you certainty, and it gives you creative freedom to come up with something that works for you and your children and your ex. Whereas if you tender the issue to a judge for decision, the judge can only do so much. The judge is bound by the family code and the law, and they just have to make their decision based upon the evidence they have and how the law applies to the evidence. They don't have much creative freedom. We've talked about it before. If there's a house involved, 9 times out of 10, if you go to trial, the judge is just going to say, sorry, got to sell the house. Whereas if you come up with a settlement, you can come up with a way to make it work. Somebody stays a little bit, you can be more creative. So I do. I recommend settling. I make more money going to trial, but I'm happy to settle cases, and it's the right result, especially when kids are involved. It's the way to go.
Yes, and I'm so proud to know you for that reason. I do appreciate that settling out of court is your first go-to, and then court is there if you need it. It's funny, right. I just had a mediation earlier today, and they spoke really amicably. I mean, it's tough just because being amicable doesn't mean you're hopping and skipping into somebody's office. It is still a tough conversation to have. It's just you are investing in yourselves and keeping that control. And it's okay if you get annoyed and a little angry. It settles down, and then you can move forward and you can make some decisions. So I'm really happy about that. And I want people to know that whatever decisions, and you can speak to this, whatever decisions you make just to get the divorce done, especially when we're talking about the co-parenting schedule and child support, it's not written in stone for the rest of your lives, especially if the kids are really small when you get divorced. Everything is modifiable. So Matthew, with everything being modifiable, do you have to go to court to get it modified, or is there an option to modify it without involving the court? And what are the pros and cons on this?
Normally, no, you would not have to actually go into court for a hearing. If the two parties have an agreement, they can reduce that agreement in writing to modify, and they submit it to the court. The court has to read it and approve it and stamp it, but most of the time they're happy to do that if it's a properly written agreement, and these folks never have to step foot into the courthouse. So if they're able to do that, it's great. They save time and they save money being able to avoid going through the court process.
Love it. So Matthew, thank you. We are at the end of our time, and I really appreciated you being here. For people who would like to get in touch with you, would you please give us your contact information?
Sure. You can go to my website, smurdalaw.com, SMURDA law.com.
Thank you, Matthew. And for all of you listening, thank you again for your time. I hope you got something valuable out of this. Child support, custody, the visitation schedule couldn't be more important, the absolute most important thing in a divorce. And so I think this was valuable time spent. Anybody can get in touch with me through my website, theamicableddivorceexpert.com. And as always, have an amicable day.
That's our show for today. Thank you for joining us. Be good to yourselves, be kind to your spouse, and cherish your children above all else.